So we start with a question that was asked in bars 2019, 2018, and 2016. And this is in relation to the rules in environmental cases. So the question is, define or distinguish the writ of Kalikasan and writ of continuing mandamus. Explain the advantages derived from a petition of a writ of Kalikasan before the Supreme Court over a complaint for damages before the RTC. So we will answer these questions by exploring and understanding the writ of Kalikasan deeper. So what is a writ of Kalikasan? It is a remedy available to a natural or juridical person or organization on behalf of persons whose constitutional right to a balanced and healthful ecology is violated. So I'd like to pause and emphasize the words on behalf of persons, because this is what's unique with the writ of Kalikasan. And then it correlates to the constitutional right to a balanced and healthful ecology. You remember what case is this? Okay. Or threatened by an unlawful act or mission of a public official, private individual, okay, emphasized again, private individual, not just an act, not just mandamus, but it includes private individuals. Okay, so as compared to mandamus, which only covers public officials who are performing their official duties, okay, that are not discretionary. So another qualifier here is that would prejudice the life, health, or property of inhabitants in two or more cities or provinces. So emphasis is in two or more cities or provinces, and this talks about the magnitude of the potential damage. So here we see the legal standing, and then we can see here the potential defendant, and we can see here the potential threat or damage that could arise from the act of such defendant. So before we proceed, I'd like to share this verse that reminds us why we should keep our surroundings free from pollution and why should we protect the environment. I'd like to share this verse from Deuteronomy 23:14. It says here that, "For the Lord your God walks in the midst of thy camp, to deliver you and to give up thine enemies before thee. Therefore shall thy camp be holy, that he see no unclean thing in thee, and turn away from thee." This talks about not just spiritual uncleanliness, but also physical uncleanliness, because the rationale here is that God himself is walking in their midst, therefore they should keep cleanliness. That's why we have a saying that cleanliness is next to godliness. That's why it's also very important on a spiritual perspective to care for our environment and guard our environment from pollutants and from destruction caused by uncleanliness from our human-made activities. So that's the verse. So in other words, we have a backup, not just from the law, the rationale, the public policy, but we can see from a very strong backup and support from a spiritual perspective, from God himself, that he is a God who wants cleanliness. So going further, what is a writ of continuing mandamus? A writ of continuing mandamus is issued by a court in an environmental case directing any agency or instrumentality of the government or officer to perform a series of acts decreed by final judgment. So kanina, it can be directed to private entities, but the writ of continuing mandamus or mandamus is directed to any agency or instrumentality of the government or officer thereof. So in other words, ministerial functions, okay, those that have to perform what they are obliged to perform. So that's a continuing mandamus, to perform a series of acts decreed by final judgment, and it shall remain effective until the judgment is fully satisfied. So from the word itself, continuing, until it is fully satisfied. So that's the essence of continuing mandamus. And then again, it directs only agencies or instrumentality of the government and not private persons. Okay, we see here again splitting the phrases. So the nature, it is a writ, and then the obligor is the government, and then the obligation is to perform a series of acts decreed by final judgment until, so this is the duration, until fully satisfied. So here's a chart of the comparison and distinction between a writ of continuing mandamus or writ of kalikasan. Okay, so please remember that these highlights have been asked in the bar exams. So for continuing mandamus, the purpose is to require the performance of ministerial duty as mandated by law, and that includes, the law includes a special law or a charter. This was asked in bar 2016. Okay, so if there's a charter, city charter, that, for example, protects or obliges a certain official to carry out an act to protect the environment, then you have to resort to continuing mandamus in that regard. However, writ of kalikasan is a legal remedy to prevent an environmental damage that is wide scale in magnitude, and it can be directed towards private or public officials. Okay? Now, we go to the advantage of writ of kalikasan, and this was asked in the bar exam. Okay? Or the while ago, the bar exam that we have read, the bar question we have read rather. So here, a writ of kalikasan is a citizen suit. Meaning, what does it mean? Citizen suit can be filed by any person, okay, any person, okay, any public interest group. So remember, either one person, one company, or a group, okay, on behalf of persons whose right to what? To a balanced and healthful ecology, okay, is violated. Okay, locus standi is relaxed. So this is the advantage of writ of kalikasan. However, in continuing mandamus, it can only be filed by a person aggrieved in such act of the government official. Okay. However, in the action for damages, furthermore, it can only be filed by the real party in interest, okay, or the person who is injured or has interest in the case. Where to file? In the writ of kalikasan, it can be directly filed with the Supreme Court or any stations of the Court of Appeals. While continuing mandamus, RTC, exercising jurisdiction over the territory where the actionable neglect or omission occurred, or with the Court of Appeals or the Supreme Court. So it can also be filed with the higher courts. However, another distinction of writ of kalikasan is that this is wide scale. Okay, this is wide scale, affecting or prejudices two or more cities or provinces, and that's why any person on behalf of other persons whose right is violated can file directly with the Supreme Court. And then this has no docket fees. And compare to an action for damages, it has docket fees. Okay, and then it may be filed separately. Action for damages may be filed separately from the writ of kalikasan. This is as provided for under the rules on environmental cases, or Rule 7. So we can find it here that besides filing a writ of kalikasan, you can file a separate action for damages. Okay, so these are the main difference. And where to file? An action for damages is of course filed with the RTC, while the writ of kalikasan can either be filed with the Supreme Court or any stations of the Court of Appeals. So that's the hallmark. These are the hallmark differences between the two. So let's look at writ of kalikasan closer, and we can find that in Rule 7 of the rules in environmental cases. So there are 5 important sections that we need to take note, and some of these have already been asked in the previous bar exams, particularly bar 2016 and 2018. So let's go to the nature of the writ of kalikasan. Let's remember that it can be filed on behalf of persons. In other words, the legal standing is relaxed, or the locus standi is relaxed. And then, as long as there is a violation of the people's right to a healthful ecology or balanced ecology, inhabiting 2 or more cities or in provinces. So that's the magnitude, that's wide scale. As to the contents of the petition, remember that it must include the circumstances of the petitioner and respondent in order to prove the qualifications above. Okay, so they must be inhabitants of two or more cities. I remember the case of Labo Galbalaan. If I'm not mistaken, it had included the writ of Kalikasan, and then we also have the petitioner, of course, because it has to be filed by what? By a private entity or a juridical person, a natural person, or what? A group of persons, such as NGOs registered under the agency of a government. And then the acts complained of, again, to qualify the wide-scale qualifier, relevant and material evidence, of course, as a requirement to support your allegations, and then certification that there's no similar action filed in other courts, in other words, non-foreign shopping, reliefs prayed for, including TEPO or Temporary Environmental Protection Order. So another feature of the contents is that there is no docket fees. Okay. Next is the issuance of the writ. The Supreme Court or any station of the Court of Appeals within 3 days from the filing of petition may file a writ or a TEPO, Temporary Environmental Protection Order. And then respondent must file a verified return within 10 days. All defenses not raised in the return shall be deemed waived. So it's like the omnibus rule, right? And then, omnibus motion rule, sorry. And then not a personal service is equal to substituted service, which we will discuss later. Since it has been mentioned, we will be discussing substituted service under the rules. And then if there is a general denial, that would mean admission. So there must be specific denial. And then the prohibited motions include motion to dismiss, extension to file return, postponement, counterclaim, cross-claim, reply, motion to declare respondent in default. So this could be dilatory in nature, so these are prohibited motions. And then court has contempt powers over a respondent who refuses or unduly delays the filing of return. So we will also discuss later the contempt powers or the rules on contempt under the rules of court. And then failure to file return, the court will hear the petition ex parte or on its own initiative. And then next we go to the hearing. There must be a preliminary conference to simplify the issues. This sounds like a pre-trial. Hearing shall not extend beyond 60 days to expedite and to achieve swift justice. And a party may file to avail the following reliefs. First is ocular inspection, entry with permission from the proper people or persons, photograph inspection. And then documentary inspection or production. Motion must establish the magnitude of the violation or threat that is calculated to prejudice the life, health, and property of inhabitants in 2 or more cities or provinces. And court has contempt powers over a respondent who disobeys a lawful process or order of the court. So the two main ones are ocular inspection and documentary inspection. Last, we go to the submission and judgment. Court submits case for decision, and court may require the filing of memoranda. And then the judgment is made within 60 days from the submission of decision granting or denying the writ of Kalikasan. Reliefs that may be granted under the writ includes respondent to permanently cease or desist acts in violation of environmental laws, directing a public or private entity to protect or rehabilitate the environment. Okay, so that's the one is negative. The second one is positive, such as to monitor, to make periodic reports, and then this one is accountability. So negative, positive, and accountability, reporting, compliance, and then other reliefs relating to the right of persons to healthful and balanced ecology. Please remember that in the contents of the petition with the Supreme Court or with any stations of the Court of Appeals, again, this is filed with the Supreme Court or the court or any station of the Court of Appeals. That's why this is more beneficial rather than filing an action for damages. And then, besides filing it with the Supreme Court, the petitioner may also file a separate civil, administrative, or criminal action against the respondent. And then, the remedy for the judgment is appeal to Supreme Court under Rule 45, appeal within 15 days from the date of notice of the adverse judgment or denial of the motion for reconsideration, appeal to Supreme Court under Rule 45, and then appeal may raise question of fact. Okay, so the writ of Kalikasan mentioned that if there's